Good afternoon. Before I give you the protocol, let me first compliment all counsel for the quality of briefing, especially in the short time that you had, to prepare for argument. But as we all understand, time is of the essence, so I appreciate all that you have done, both in terms of the briefs, the affidavits, the reply. All of them are extremely helpful for us in terms of deciding this case promptly, which we expect to do. Protocol, as I think you have been explained by Clerk Keneally. Mr. Jones, you will go first. You will have roughly 3 minutes to speak without interruption from the justices. If you finish earlier and wish to invite questions, you may do so. The questioning will begin with Justice Lank, our most senior justice, and we'll go by seniority. I will ask questions last. After I ask questions, I will invite all the justices, if they have any further questions, to ask them. You have 15 minutes or until the questions and answers end, whichever comes first. And of course, Ms. Sturman, the same protocol will apply to you. Mr. Jones, are you ready?
I am.
All right, you may proceed.
Good afternoon, Mr. Chief Justice, and may it please the Court. This is Robert Jones on behalf of the petitioners. In the current public health crisis and in the face of governmental orders requiring citizens to stay at home, for non-essential businesses to close, for groups of over 10 people not to gather, and for all persons to practice social distancing, the typical in-person activities required to gather signatures that would allow petitioners to qualify for the election ballot under Massachusetts law are largely impossible. In this environment, the minimum signatures law, Chapter 53, Section 6 and 7 of the general laws significantly interfere with petitioners' ballot access rights under the Massachusetts Declaration of Rights, as well as under the U.S. Constitution. And it should be mentioned, interferes with the rights of voters as well. For this reason, the law must be reviewed under a strict scrutiny standard, which in view of the overwhelming interference imposed by the COVID-19 health crisis, it cannot withstand. This court has the authority to provide the urgent and immediate relief that the petitioners need to manifest in this court's authority to declare the constitutional violation and declare the constitutional violation and order the petitioner's law to be not it also is within the court's authority possible.
I'm sorry, Mr. Jones, we're once again having difficulty hearing you. I don't know why. Why don't you proceed? But if we may have to do something different. But go ahead. We've heard you so far, but you're beginning to get crackly.
Thank
you.
Go ahead.
All right. Can you back up 2 or 3 sentences too? Because I didn't hear the last 2 or 3 sentences.
The court has authority to provide immediately for the petitioner's need is met to authority to declare the constitutional violation and order that the petitioner's law not be enforced. It also is within the court's authority to seek, where possible, alternative duties to the circumstances in which this matter arises. The Secretary appears to agree with petitioners on all of these points: the impact of the health crisis, the significant interference imposed by the signatures law in this setting, the application of heightened constitutional scrutiny, the court's authority to provide relief, and the urgent need for it to do so. I'll be happy to respond to questions addressing any of these areas of broad agreement, but I want to address very briefly where the petitioners stand on the question of in his papers. The Secretary nods a separate element of an order from the court that invites us to do constitutional violation.
I'm having great trouble.
Yeah, we're having no trouble again. Are you on a landline or a cell phone?
I have a landline.
Sorry, landline.
Maybe you should try a cell phone.
Yeah, why don't you try? You have a cell phone with you? I assume you do.
I do.
Yeah.
I do.
And how is the cell coverage where you are?
It is the phone I was to start with.
Sorry?
It's the phone I was using to start with, so I will try back that phone if the court would prefer. Can you hear me?
We can hear you sometimes. Sometimes you're clear as a bell, and sometimes you're not. This is the first time we've had this difficulty. So, but at least we know you've completed your 3 minutes, so we are at a point in which it's easy. So why don't you hang up and then call back on Estelle, and we'll commence with the questions. We'll try that.
Okay.
Now exiting
Robert Jones.
Now joining
Robert Jones.
Your Honor, I've joined the line.
Okay. And are you on speaker or are you on?
I'm not on speaker.
Okay, good. Okay, so hopefully everyone's on. If anyone is on speaker, please go to mute unless you're speaking. So, okay, we're going to proceed now with questions. Justice Link.
Yes, good afternoon. My first question, I guess, is to just sum up where it is that you stand. I mean, you and the Attorney General seem to be in agreement about the problem, but it's the remedy that you disagree about. Is that a fair statement?
It is, Justice Link, and that was the last part of what I was going to begin by saying, so I'll tell you where we stand. We have some concern about the elements of the potential remedy that have been outlined by the Secretary in his papers. And we understand the elements that are described in those papers to consist of three things: a substantial reduction in the number of signatures required, a modest extension of deadlines for certain candidates, and the allowance of electronic signatures under certain circumstances. The concern we have to start is that a reduction in the number of signatures in the amount that's described in the Secretary's papers has no rational or coherent justification that we can see, and may prove to be illusory to the petitioners and to candidates who are similar situated. The elements of the proposal offered by the Secretary in his brief really seem to mimic a proposal advanced but not passed by the state legislature in recent days. And it's a proposal that carries with it the impression that it was calibrated more to protect the incumbents than really to lift the constitutional harm that this petition seeks to get at. There's nothing in the record, and nothing otherwise logically supports a reduction of signatures by just 50%. There's no reason to think that campaigns that are not supposed to be operating in public, relying on volunteers who are not supposed to be out but are supposed to stay at home other than for trips to the doctor or the grocery store, would have a reasonable chance of gathering 50% of the required signatures, whether it's 5,000 or 1,000 or 75. When the voters needed to sign or otherwise not out in public, individuals are advised of social distancing. The conduct that is required to canvass for signatures reasonably would cause people to have concern for their health. So there's no reason why the 50% proposal makes sense, and we would also submit that there's no reason why the relief of some substantial reduction in the number of signatures, if that were to be a portion of this court's remedy, should only be extended to candidates who have to gather more than 1,000 signatures. There's no conceptual reason why that relief shouldn't extend to all of the candidates who are suffering the same constitutional harm, and that surely includes the candidates for House, District, and Senate offices as well. all of the typical, all the impediments to the typical process, including the rapid close, sometimes the procedures that are applying.
I can't hear you again.
All of that applies to those candidates as well. So it's possible that the most tailored way to remedy the constitutional harm in this instance, with 12 days to go before the next deadline, is to declare that the statute is unconstitutional as applied in this context, and to do away with the signature requirement. But if the court
doesn't that raise a significant question about whether or not that in any way serves the Commonwealth, the Secretary's obligation to try to protect the integrity of the ballot? Because couldn't you just have all kinds of people jumping in and saying they want to be on a ballot?
It may be, Your Honor, that some number of candidates who would not have raised their hand to run for office would. We don't know that.
No, we don't know a lot of things in this world now.
That's true. And one thing we do know, though, is that in order to prize that state value of serving as a gatekeeper for a very lengthy ballot, in this instance means deprioritizing and indeed really harming substantially the constitutional ballot access rights of these petitioners. And that's a very tough position for this court to be in. And it's certainly one that the legislature might have saved the court from being in, but it has not. And so we think that if there certainly is a tailored way nodded at in the Secretary's papers. We think if the court is looking for a coherent way to address the number of signatures question, as we submitted in our reply brief, maybe the available coherent basis upon which to do that is to take the amount of out of the yellow.
I'm sorry, I can't hear you.
We would submit that the one coherent way possibly to arrive at a reduction in the number of signatures would be to take account of the amount of time that the candidates had out of the typically allotted time, and to knock and for this court to order that the number of signatures would be reduced by 2/3.
And that would be in combination, or that would be standing alone as a solution?
In our view, Your Honor, respectfully, we would submit that that would work in combination with the deadline extension, modest extension that is acknowledged by the Secretary to be practical, and along with the allowance for electronic signatures, which we think is perfectly in keeping with the statute as it's currently written, and would further ease and make more assured that the relief that the court offers to these candidates will not be illusory.
Let me ask you more about the electronic signatures, which I don't really completely understand. Now, I understand that there's some obligation on this. Is it the Secretary's part, or is it upon the local election officials to compare signatures against some model signature? I'm not sure what's being compared. Who has the obligation to do that?
I believe at the level of the Secretary's involvement, there's an opportunity for challenges to be made on the basis of big signatures. The local authorities certify that the voter that has signed the petition is a registered voter in the district in which he purports to be, he or she.
But is that each level is a comparison then of the signature that's on the nomination papers, along with a comparison with what? Where is it being compared with?
Yeah, my understanding is that it can be compared in the case of an objection with an actual signature from the voter if the objection goes to that level. I would say that in our understanding of what the Secretary has laid out as being possible, what would be different or additive, if you will, here is simply that the campaigns would have an opportunity to gather the signatures electronically through various means, and that they would then take those and then have an opportunity to print those petitions on which electronic signatures have been placed, and then take those petitions in very much the identical way that they do today, carry them, mail them, get them to the town clerk's office. The town clerk would certify them in just the same way that the town clerk does by accessing a state database, and then the challenges would unfold in just the way that the state law currently contemplates. I understand this is one of the reasons why the Secretary does object issue any electronic signature that would allow a voter to simply type his or her name, because that typed name does not allow for the challenge that Your Honor is asking about that can be made once the signatures reach the Secretary of State's office.
So am I correct in understanding you to be saying that you'd be happy with the electronic signature collection scheme that the Secretary proposes in his brief? Is that right?
If that electronic signature is one part of a broader, more tailored...
I understand that. I mean, if we're talking about electronic signatures, that's the kind of electronic signature that you have in mind, in other words.
With 2 weeks, 3 weeks, 4 weeks to go, I think that's the kind of electronic signature that we're going to have to live with, Your Honor.
Okay, all right, okay. Because I was very wondering what was going on, because if you look at the amicus brief, it talks about some act that I wasn't even aware existed, candidly, an act automatically registering as eligible voters and enhancing safeguards against fraud, which has been around, I guess, since 2018. I think that I don't even know what impact that would have on it. Maybe I should ask this of the Attorney General. Maybe I will. But if you know anything about this, I'd be very interested in learning about it.
I don't. Not as much as I should to answer the question, but I will say this, Your Honor, that there is, upon learning more about electronic signatures, there's every reason to think that there are protections and audit trails and all sorts of security aspects to electronic signatures that in the long run might likely give state governments more confidence in deploying those tools for these purposes. But we're not pushing for the state to build out a large digital system in the course of 3 weeks. We're just talking about gathering signatures electronically and then roughly moving them through the process the way that regular old signatures are today.
Okay. I don't have any more questions. Thank you.
Justice Graziano.
Yes, thank you. One of the proposals for equitable relief that you include is that we declare candidates who have commenced good faith efforts to have collected the signatures. Who decides whether good faith efforts have been done?
Yeah, Your Honor, that was one element of a potential approach that we recommended in our initial petition. I think at this point we're comfortable not pressing for that to be part of a package for relief if that relief otherwise includes the other 3 points on which the two sides agree. I would say that in a world in which it's impossible to talk about some of these other forms of relief because they're not practical, and we're hearing from the Secretary that they may be, a declaration along the lines that you just described and that we proposed would be a second or third best option as a way of moving candidates towards the ballot, and which may, to be sure, require Superior Court justices or otherwise to handle one-off petitions down the road to be sure that people have satisfied that standard. But that's not where we are right now.
Okay, so your proposal is either it's void or we go to 2/3.
Exactly right.
All right, I have nothing further. Thank you.
Justice Louie.
Thank you, Chief. Mr. Jones, I want to talk to you about your suggestion concerning extension of deadlines. And where do you see the fat in the timetable where the deadlines could be extended, considering the ballots need to be sent to the military and overseas no later than a certain amount of time, I think 45 days prior to the federal election? Where are we going to squeeze additional time from?
You know, I understand we started at the base point, which I understand.
I'm sorry, I lost you.
Let me start with, and I understand that the area is allowed the deadline can't.
I'm sorry, you're fading in and out. You were fine right before this.
Can you hear me now, Justice?
Yes, perfect.
It's my understanding that the Secretary is allowing that it would be possible for there to be extensions of the state and of the county and district candidates. Okay, that would good too. beyond that, this is a question that is affected the Commonwealth. They will better set with those.
I'm sorry, you faded out right after you mentioned the county candidates. You faded out again.
Beyond that, Your Honor, the room in the calendar to the question as well. It strikes us that having insight into the actions of the ballot printing and objections process, that there ought to be space there if it were needed. But our current expectation is that with either a declaration that the signatures limitations will not be enforced, or with something like the package that we've reflected in our reply brief, and the current dates with the modest extension, we should be content.
Thank you.
Justice Bud.
All set, Chief.
Justice Bud.
Hi, good afternoon. I may have missed it, but can you explain how you got to the 2/3 requirement? Just having.
Yes.
Yes, please.
Yes, Your Honor. The nomination papers were made available February 11th. Mm-hmm. The governor's emergency declaration was March 10th, and the stream of orders around the COVID emergency really started about that date. And so roughly the candidates had about 4 weeks of 11 to 12 that they typically would have to gather signatures. It's imperfect as logic because I think everybody would understand that the campaigns don't typically assume that they have got to put in steady efforts evenly on each day of that period. It is true that immediately following those emergency orders, there are ways that the campaigns have been able to canvass for petitions. It's just distanced and by mail and a lot less efficient and a lot slower. It's also true that before March 10th and the emergency declaration, this public health crisis was already having an impact on the campaign's ability to canvass for signatures. Nonetheless, this is one place where at least we see in the record a reasoned basis of some kind for the court to draw a line that is as low as it can go, to put it in lay terms, so that we can be as assured as we can be that the court's remedy is not illusory.
Okay, and just to be clear, you're saying that the would-be candidates would only have to collect 1/3 of what they're supposed to, or what they ordinarily collect.
That's correct, Your Honor.
Okay, thank you. That's it.
Justice Seifer.
I have no questions. Thank you.
Justice Kafker.
So my understanding is that the constitutional issue for the remedy is we need to come up with the least intrusive remedy possible, right, for the constitutional violation. Is that your understanding as well?
That is my understanding, Your Honor.
And I'm trying to understand, and the only thing that's a violation of the Constitution is the in-person requirement, right? There's nothing wrong with these numbers, besides the fact that we've got the numbers in and of themselves are fine, right? There's no constitutional problem with requiring a substantial representation of people. It's just the inability to talk to them in person, right? That is the constitutional violation, right?
I'd press on that just a little bit, Your Honor, to say that the numbers do have, in the current setting, the numbers do operate to impose a significant interference on these candidates because it is surpassingly difficult to imagine that many candidates are going to have success reaching some of these thresholds when the places that they typically go to canvass are empty by order, when people are supposed to stay away from one another by order.
No, I totally agree with you on that. I'm just trying. If we had a workable electronic signature process, this would be a non-issue, right?
Except, Your Honor, that I would submit that the statute might have been drafted differently with a workable electronic signature in order to reflect what's possible when you're collecting signatures electronically. The current numbers are set in contemplation that people are going to be able to gather signatures in the in-person way, and that's reflected in many of the decisions. And because we don't have a good feel for what the yield will be from the electronic efforts, we have a very good sense that the through-the-mail efforts are much, much less efficient. And so it's very difficult to think that the legislature would have set the same number if it were contemplating different means.
Right, but I guess it's just hard for me to imagine, in the Twitter, Facebook world, that a viable candidate can't, if an electronic signature system is workable, get, that percentage of the voters in his or her district to sign, right? I mean,
your intuition is mine, Your Honor. I would simply say two things. One is, we won't have the 12 weeks. We'll have 12 days. And also, we don't know how this particular electronic signature system, if it were in place over the next 12 days, we don't know how that would hold up, for example, during the objection phase. You'll have people signing with a mouse or with a stylus. What opportunity will that give candidates to object to those signatures, and how will the commission respond to those objections? We don't know any of those things. We don't know how the town clerks will respond. And so it's difficult to view one lever as being sufficient to address the constitutional harm.
And I guess my last question relates to either the eliminating two-thirds, eliminating half. Are you aware of any cases where the constitutional remedy is that specific, where we change a statutory percentage like that?
I don't have one in mind, Your Honor, and it's one of the reasons why, acknowledging the very difficult call that the court will have to make, it's fair to say that it may be, put it this way, the separation of powers issues that lurk when these sorts of discussions are around. Manifestly, this court can declare the signatures requirement to be unconstitutional and simply not enforce a signatures requirement. That poses, it seems to me, no authority issues at all.
But that eliminates the statutory purpose of getting at least some number of people to demonstrate that someone has a meaningful level of support in the district, right? Then we're wiping out the purpose of the signature requirement altogether, as opposed to trying to refine it.
Your Honor, I concur with what you described, and I would say it prizes one constitutional interest in place of another in circumstances I think would be appropriate to do so. What is where the court gets into trying to find a place to set that signature requirement. Yes, it does wade into a little bit more of a natural place to be. I think it's clear from the cases that the court has that authority, that especially has that authority where the legislature has had an opportunity to act and has not, and where it is necessary to remedy this type of a constitutional injury. So it's not typical, and not welcome, perhaps, but it is where we are today, I think.
Thank you. No further questions.
Chief Justice Gantz, I've got only one question. If we do not accept your view that it is void entirely and that there must be some amount of signatures, do we have any choice but to establish a percentage or a number?
Your Honor, I don't think we've arrived at one that we think is any more principled than the 1/3 requirement that we've articulated in our reply brief. It's a very difficult, almost policy-like judgment to have to make here in the middle of the process. And so the best proxy, if you will, that we can find for measuring and assessing the extent of the constitutional harm and remedying it is to look to the amount of time that's been taken away and essentially take advantage of that as a measure of rough justice, if you will.
But I mean, you're claiming that there's a constitutional violation as applied to these particular circumstances, and therefore it demands a remedy, correct? And it's not as if we're engaging in policy. We have to find a remedy for a constitutional violation. That's what courts do when they find a constitutional violation, correct?
That's correct.
So, is it a policy question or simply a matter of remedial judgment as to what the percentage or number should be?
Well, in the hands of this court, it's a remedial judgment. I concur, Your Honor. And I think the same tools and reference points are available. And to your question of whether we've identified one that we think, beyond simply a declaration that it can't be enforced, is preferable or more reliable, we think that the most reliable we've been able to identify is the time that has been lost.
Okay, but that implies that there is no ability after essentially March 10th to gather signatures, as opposed to some modest ability, does it not?
Well, it's imperfect, but it recognizes that there both is an impaired ability after March 10th, but also an impaired ability before. This virus didn't arrive on March 10th in people's consciousness or otherwise, and the ability of volunteers and campaigns to be out and canvassing leading up to March 10th was also impaired in amounts that I can't quantify or measure, but are logically, I think, pretty clear.
Okay. I have no further questions. Does any justice have any other questions? And hearing none, Mr. Jones, thank you. Sorry you had technical difficulties, but we worked through them.
Thank you, Your Honor.
Ms. Sturman.
Yes, Your Honor. Thank you. Good afternoon, and may it please the Court. The parties agree that the statutory requirements governing the collection and submission of nomination signatures in order to secure a place on the ballot are, under ordinary circumstances, constitutional. And even in the current pandemic, the petitioners do not cast doubt on the important reasons why those requirements exist: to ensure that voters are not forced to wade through a ballot crowded with candidates who have no measure of public support. The parties also agree that during the current pandemic, the nomination signatures requirements pose a greater burden on candidates seeking ballot access than they would ordinarily. But the Secretary cautions that adopting all of the petitioners' requested remedies would create unworkable disruption in the ability to administer a sound election on September 1st. The question then is what remedy is appropriately tailored to addressing this burden while taking into consideration the valid purposes behind the requirements, as well as the ultimate necessity of orderly election administration. To this end, the Secretary endeavored in his brief to describe the many other moving parts of this election cycle that are dependent upon and keyed to the submission of nomination signatures, including the diffuse process of certifying signatures by local election officials in the Commonwealth's 351 cities and towns, the subsequent process by which challenges to certification are made and adjudicated at the State Ballot Law Commission, and the preparation of 2,200 different ballots that must be carefully checked, in some instances translated into other languages, and then transmitted to local election officials. All of this must be done in time to comply with the federal requirement that local election officials transmit ballots to military and overseas voters by July 18th, or 45 days ahead of the September 1st primary. Taking the petitioner's proposed remedies in view of these important legal and practical considerations, the Secretary submits three potential ways in which the Court could address the petitioner's concerns while honoring the purpose of the nomination signatures requirement and minimizing disruption to the orderly administration of the September 1st election. Reducing by 50%, as has been suggested in the Senate, the number of signatures required for candidates who would otherwise be required to gather 1,000 or more signatures. Extending the submission deadline for county and district candidates by 1 week to match the deadline for candidates for federal office, and/or adopting a limited form of electronic signatures that would appropriately account for the resource and cybersecurity issues described in more detail in the Secretary's brief. Thank you, and I'm happy to take your questions at this point.
Okay, Justice Link.
Thank you. Good afternoon. I guess my first question is having to do with the difference between your proposals as to the elements having to do with 2/3 and 50%, and yours is 50%, but not as to the lower amount of voter signatures required for two of the offices, I guess. You want to do it over 1,000 votes. 1,000 for signature requirements. and they don't. They want to have it apply to everyone. I want to know what the difference is from a principled basis as to what difference does it make as between your proposal and theirs.
So I think in making the proposal and in evaluating the petitioner's proposal, the Secretary appropriately looked to what has been proposed in the legislature thus far.
But they haven't done anything. They haven't suggested that they, in fact, agree with that. All we know is that somebody sponsored it and did that, right? I mean, it's not like if the legislature has adopted anything. We haven't got anything to indicate that the legislature, in fact, does want a 50%.
The Senate bill was engrossed by the Senate this morning. And my understanding is that it will be transmitted to the House of Representatives. Your Honor is right that it's difficult to predict what the House of Representatives will do with that bill. And it is, to be sure, not the same type of guidance as knowing what the entirety of the legislature has agreed to pass. But it is nonetheless some guidance. And it is a reflection, perhaps, of a legislative determination that not just the number of signatures differs in races where one might be required to gather 1,000 or more signatures as opposed to far less, but also the nature and character of the operation and the efforts that one might employ to get those signatures. So one could envision a situation in which the legislature thinks that a percentage reduction might be appropriate, but that the same percentage might not appropriately apply across the board because, frankly, the character and the nature of an effort to gather 150 signatures likely looks a lot different in implementation than the effort and required to gather something more on the order of 10,000 signatures. It is also true that it's appropriate to look at the objective number, the absolute number of signatures that would be required after implementing such a reduction, and the legislature might well have determined that applying a 2/3 reduction to a state representative candidate, which would then require them only to get 50 signatures, would place that number now so low as to not satisfy the constitutional and purpose behind the statute, which is that candidates ought to demonstrate a substantial measure of public support before they gain access to the ballot.
Okay. Yeah. Now, did you answer my other question about the 2/3? Yes, I guess you did. All right. The next question I have is, I know it's a really basic one, but I don't understand what's included in the term nomination papers. I don't understand what's involved with that. Could you tell me what nomination papers consist of?
The nomination papers consist essentially of a form to be signed by voters in support of a candidate's placement on the ballot.
Are there multiple copies of this given out to candidates, or is it just only one? It's like a master sheet. I mean, I don't understand how it works.
There are multiple copies that are given to candidates, and also the candidates may make copies so long as they are exact replicas and don't.
You mean they have to be two-sided, in other words, like yours are?
I'm sorry?
Are they two-sided? Are the originals two-sided?
They are, Your Honor.
So they have to be exactly like that. They have to be exact replicas of that, and they have to be two-sided. Of course, you don't have a two-sided printer.
They are to be exact replicas. The one area in which there's flexibility is that I believe they are originally distributed on 8.5 by 14-inch paper, although the Secretary has counseled candidates that you may shrink the size to fit on standard letter-size paper so long as it is otherwise an exact replica of the nomination papers.
Well, why would you need to have it be an exact replica and it be two-sided as opposed to just having it be on one side and then 2 pages as opposed to two-sided? What's the difference between the two?
Between having it two-sided and having it one-sided with 2 pages?
Yeah. I mean, if you could do the 8.5 by 11 as opposed to 8.5 by 14, why can't you just change that too?
I think the Secretary's position would be that the information contained on the back of those nomination papers, which include the penalties for fraud or fraudulent or forged signatures, are critical, and we want to make sure that the voters who sign the papers are aware of that information, and there's a risk that if it were printed on 2 separate pieces of paper, they might become separated, and the voter might not have the opportunity to review that.
Okay. And then the last question I have is the one I already asked your brother, which has to do with the ACT test in 2018 as to eligible voters and enhancing safeguards against fraud regarding electronic signatures, which would apparently permit the comparison of signatures with electronic signatures with a database, right?
So So I believe that Your Honor is referring to the automatic voter registration legislation that was enacted in 2018.
Yeah. There was I've only seen this referenced in the amicus brief. I haven't seen it referenced anyplace else.
So that does have a very limited provision for electronic signatures under very specific sets of circumstances that carry with them safeguards that would not be present if we were to wholesale allow electronic signatures on nomination papers. So in the automatic voter registration context, we're talking about the transmission of electronic records between government agencies. So from the Registry of Motor Vehicles, for example, or Mass Health to the Secretary, along with an electronic signature that might be administered, for example, by using an electronic pad that is a part of the equipment at that state agency and has been properly vetted for security concerns as well as accuracy. So it is accurate to say that the automatic voter registration statute does employ a very limited and prescribed form of electronic signatures, but I think the Secretary would caution that it's limited for a reason, and that appropriate study was able to be done to ensure that the cybersecurity and the integrity of those signatures could be maintained. And the concern with sort of throwing the doors open at this point and employing a wholesale new system of electronic signatures is that while it may well be the case that there is some system that might be workable, adopting one without first studying that and making sure that it's workable, making sure that it meets the cybersecurity constraints.
Well, that's been around since 2018, hasn't it?
This was in 2018, yes.
Yes, it's been 2 years.
It has, but we're not, in the AVR, the automatic voter registration context, we're talking not about, a person on their phone or their home computer signing with a finger. We're talking about someone at a state agency using approved state technology.
Yeah, I get that. Now, could you tell me, though, I'm having trouble understanding who it is that does to compare signatures to other signatures. I'm not sure okay, so let's assume that you have the wet signature on the nomination papers. What is that getting compared to, and who does the comparing?
So there is no, the local election officials are not charged with doing a handwriting analysis or a comparison of those signatures.
So they're not looking to compare it to anything, in other words.
They are looking to verify that name is of a voter who, in fact, is registered.
Yeah, it's a name. It's not a signature, though. That's my point.
That's right.
I don't mean to interrupt you, but I just really want to get to the point here, which is that it's not a comparison of signatures, in other words, at that level.
That's right. The place in the process where there is an opportunity to challenge the authenticity of a signature is at the State Ballot Law Commission, where objections can be made alleging that a signature is the product of fraud or forgery.
Okay, got it. All right, thank you. That's what I need to know. Thank you.
Mrs. Gaziano.
I have no questions. Thank you.
Justice Louie.
Thank you, Chief. I guess I want to ask you a little bit about what's going on in the legislature and the implications for our decision. So, a bill's been engrossed by the Senate. It's going to be taken up in the House. We've already addressed the issue that we're not really engaged in policy, but rather a remedial judgment that can't, as Justice Kafka put it, be any more intrusive than is necessary to make sure this signature requirement is constitutional. So, in the face of legislation that might be imminent and might not pass at all, where are we?
Well, I think we are left in a position where we can take some cue and some instruction from the parameters of legislation that has garnered some measure of support within the state legislature. It has not passed. It is perhaps not dispositive of the question of what remedy this court should implement, but I would submit that it does have some value and some import in the court's analysis as to the proper remedy.
I guess I'd be more direct about my question. I appreciate that. I mean, we also have the Secretary of State who's in charge of addressing these issues in elections, who's suggesting a 50% reduction. But my question goes more toward restraining, addressing an issue where there might be legislation that addresses it, since we're not engaged in a policy decision here. On the other hand, we're in a situation where every minute counts.
Sorry, Your Honor. I'm sorry. I didn't mean to.
No, you did. You did. I was just going to add, and I assume that did you say the House was taking this up today?
We don't know, Your Honor. It was just engrossed by the Senate this morning.
Mm-hmm.
So I can't represent one way or the other what the House intends to do with it. I think under ordinary circumstances, and we acknowledge that the circumstances here are anything but ordinary, but under ordinary circumstances, there might be a preference to see the legislature deal with this. And Your Honor very appropriately, I think, recognizes the time sensitivity of the issue at hand. One possible solution or method of addressing it, I suppose, might be for the court to give the legislature some opportunity within the House to take some action on the bill with some sort of timeline after which the court might impose its own remedy.
Thank you, Ms. Norman. That's all I have, Chief.
Justice Budd.
Oh, I have no questions. Thank you.
Justice Leifer.
I just have one minor question, and that might be just because I've been a judge too long and haven't been allowed to sign these papers. I've never, when I used to be able to sign them, I've never turned them over to read the back. Is that something that happens? I mean, I'm trying to link that up, the signing of it and what's on the back being important.
I mean, I'm not sure I can answer how often that happens as a practical matter, but the back of the paper is also where the clerks apply their certification notations. So I think there is a concern about keeping those physically on the same piece of paper so that the secretary can be assured that the certification applies to the signatures appearing on the front and the pages weren't redistributed or restapled.
Okay. Thank you. I have nothing further.
Justice Kafka.
So are you aware of any cases where the constitutional remedy is this precise 50% or 66% of, we're deciding there's a problem with in-person visiting, so we're going to cut it to 50 or 60%. Are you aware of any cases like that? And if so, could you tell me so I can look at those?
I'm not aware of any cases that reach that sort of numerical level of precision. But I do think it's fair to say that the case law allows the court to design a remedy that would be narrowly tailored to address any constitutional violation it might find.
So why is it a narrowly tailored remedy, one that provides a open-ended signature process, electronic signature process? And specifically, what is the ballot commission, when they investigate that, are they doing handwriting analysis? I mean, is this handwriting analysis, whether it's wet or typed in, is it meaningful at all? I'm just trying to understand what the purpose of that is.
So once it gets to the State Ballot Law Commission, Your Honor, I don't know whether, forensic handwriting analysis is the right way to describe it, although that certainly could be involved. But at that point, it operates the same way litigation in courts does, in the sense that it's an adversarial proceeding where an objector can offer evidence supporting the allegation that a signature might be the product of fraud or forgery. And that allegation...
Can we do that just as easily with an electronic signature?
Well, I suppose I would back up for a moment. In part, the answer to that question, Your Honor, depends on what you mean by electronic signature. So, for example, if one were to deem that an electronic signature could include a typed name, it would be substantially more difficult to make a determination about whether the name...
I was looking at the electronic signature submitted by the amicus from an 85-year-old woman in a nursing home using a standard electronic signature process. It tells where she lives. You've got it signed by a professional corporation application. I just don't know why that isn't that a much simpler solution than trying to come up with percentages that are appropriate? Just seems to me that that's, in this day and age, we should be able to do that, shouldn't we?
I mean, I'll acknowledge, Your Honor, the challenge in designing an appropriate remedy here, regardless of which path the court chooses. With respect to electronic signatures, I understand that it seems odd that all of this technology that many of us take for granted and use in other contexts is not yet employed in the administration of Massachusetts elections. And I think the important thing to consider right now is the circumstances under which the court is making this decision. So while, as I said a few moments ago, it may well be the case that there is an electronic system, whether it's DocuSign or some other system, that might, after careful vetting, prove to be effective and useful and not problematic within the Commonwealth election administration. I think the Secretary would caution the court against leaping too hastily into adopting such a new...
Well, can I ask about that then, because you may know the answer to this. So the ballot initiative, according to the amicus, and again, we're all scrambling to catch up here, the ballot initiative signatures don't need to be wet. Is that correct?
That's not correct, Your Honor. They also need to be wet signatures.
So how are we going to do this when, a week from now, when the ballot initiatives, when are the ballot initiatives due?
So, the signatures right now is the period during which the legislature may act to adopt any of the proposals offered by the ballot initiative. Their period to act. If they don't
adopt that.
I'm sorry?
Mm-hmm. If they don't act, how many signatures need to be collected in that process?
So if the legislature doesn't act by May 6th, the petitioners will need to gather 13,374 signatures in a period of approximately 6 weeks.
And so they're going to need to collect 13,000 signatures, which are 3,000 blankly blank more than the most here. You're saying those need to be wet signatures as well. Okay. That seems like we've got another crisis coming down the road then. Is that right?
That may be.
Unless we free up the electronic signature process.
I mean, I can understand the desire to try to solve as many problems as possible, certainly when we can foresee problems that may be coming down the road. But I want to make sure to be clear that with respect to the initiative petitions, the legal landscape is different because the signature requirements for those petitions is constitutional rather than statutory. So I do think that that is a separate issue that merits fuller consideration and briefing by the interested parties before the court were to reach a decision on that.
Okay. The last question is follow up on Justice Lowey's question. My understanding is the House is in session today to deal with another law, the eviction law. I don't know, but if it passes, if the legislation passes that was in the Senate, is it your view that it's constitutional? That the constitutional crisis is solved by that?
I mean, there could certainly be an allegation, I suppose, that the remedy the legislature chose to enact does not sufficiently alleviate the unconstitutional application of the requirement on candidates like the petitioners. But then I think we're looking at a different analysis where we have a clear legislative enactment that expresses what they believe the appropriate policy approach is. So it's not that it would foreclose any further challenge, but I think any such challenge would be on different grounds and in a different landscape than the one currently before you.
But again, the proposal in that is 50% for at least all the federal officers. It doesn't address the state officers. Is it your view that that is constitutional even without any change for the state officers?
So It actually is not quite as bright of a line. It would apply to candidates who need to gather 1,000 or more signatures, which would include, for example, candidates for governor's council. So it's actually not just federal offices. And as I think I mentioned a few moments ago, I think we can all theorize as to the reasons why the legislature drew that line where they did, but certainly one very plausible explanation is that the scale and nature of an effort required to gather 1,000 or more signatures is very different in nature, not just in number or amount.
One of the petitioners here is seeking state office, right? Or two, I can't remember. So if this passes, is it the view of the Secretary of State and the Attorney General that it's constitutional in regard to this litigant if it passes?
So if it passes, I think it is certainly the Secretary's view that it remains the case, and I don't think petitioners really quarrel with this, that it is constitutional and appropriate to require candidates to show a level of public support before they gain access to the ballot, and that the threshold of 150 signatures is qualitatively and quantitatively very different than a threshold that is much higher, like 1,000.
Okay, I have no further questions.
Chief Justice Gantz, I know that you have recognized, the Secretary has recognized that the pandemic has imposed a far greater burden on candidates to obtain signatures. But I don't know that you have said whether or not the current statutes that apply, which I guess are Chapter 53, Section 6 and 44, is that correct?
That's right, Your Honor.
Whether they are unconstitutional in the context of a pandemic. Are they?
I think the Secretary, for purposes of this litigation under these circumstances, has conceded that a heightened level of scrutiny ought to apply.
That's not my question. Is it unconstitutional? I know a heightened level of scrutiny is to apply. And then the question is it, in view of the heightened scrutiny, unconstitutional as applied to the context of this pandemic?
I think on these facts, and as applied to these petitioners, yes.
Okay, so we have a statute which, as applied to the context of this pandemic, is unconstitutional, and therefore we have an obligation to remedy that constitutional violation, correct?
Yes, Your Honor.
Okay. Does the Secretary himself have an obligation to remedy a violation that he recognizes to be unconstitutional?
I think the Secretary is limited by his statutory authority, Your Honor, which he views to not include the ability to implement something like redefining what constitutes a signature under the statute or changing the statutory requirements as to the number of signatures required of candidates.
So your suggestion as to what we could do with electronic signatures, which is modest but not insubstantial, is a suggestion that he does not believe he has the authority himself to implement. Is that correct?
That is correct, Your Honor.
So he requires the court to order it if it is to be implemented.
That's right.
All right. Now, with regard to the ballot question, that's not before us, correct?
That's right, Your Honor.
No one has sought relief with regard to that, at least as of this time. The House is in session today, I gather. Is that correct? Do you know?
I believe so.
Is it in session tomorrow?
I don't know the answer to that question, Your Honor.
Is it in session on Saturday or Sunday or Monday?
We believe they're in session on Monday. Oh, no, I'm sorry. I'm corrected. Monday is a holiday. So I don't know the next time the House will be in session after today, Your Honor.
So if the House does not act today, are you suggesting that we should wait to remedy a constitutional violation?
I don't think the court is obligated to do so. I was suggesting that is one option.
Wait to win. I mean, you're basically saying the best right now. That legislation does not even extend it beyond April 28th, correct?
That's right. So for county and district candidates.
So it's April. Time is running short. I'm trying to get a sense. We're in obviously a difficult posture. Is that we are prepared to act promptly. We'd be quite happy if the legislature were to decide to take this away from us. But if they don't, do we not have an obligation to remedy a constitutional violation?
No, I think you do, Your Honor.
With regard to the electronic signatures proposal, do you agree that that has limitations in terms of the number of people pragmatically it could reach?
Yes, Your Honor, and certainly depending on which electronic signature proposal we're discussing. But absolutely,
I'm referring to yours.
Yes. I think the suggestion that we've made, while there might still be disparities in the resources and the ability of voters and candidates to avail themselves, is much more minimal in that respect than other possible electronic solutions.
Okay, so you recognize that it's a help, but it's not going to be enough in itself in the absence of some reduction in the number of signatures.
I'm not sure I agree with that, Your Honor. I recognize that there will be some inequality in the ability of candidates or voters perhaps to avail themselves of the electronic option. I don't know that necessarily leads to inexorably to a conclusion that an electronic option must be paired with something else. And I also think it's important to remember that mail remains an option that candidates, including non-incumbent candidates, have been using successfully even during the time of the pandemic.
But is it not fair to say that if we were to rely entirely on an electronic signature solution, there are some who could say that favors those individuals not only who are technologically savvy, but who have the resources to have computer systems and some degree of sophistication in using them?
I think it's true that inherent in any electronic signatures-based solution, there will be some disparity in the ability of candidates and voters to avail themselves of it. I think that's true of the same could be said of a whole host of things with respect to campaigns who are differently resourced and have different abilities to avail themselves of different types of systems to satisfy their signature gathering requirements.
Yeah, I'm not referring to the amount of money the campaign has. I'm referring to the amount of money that the voter has. Are poor people who may only have smartphones, going to be able to use an electronic signature?
I think in the manner in which the Secretary has proposed, in which we're essentially talking about the electronic transmission of an otherwise wet signature, it would implement the lowest sort of barrier to entry for folks availing themselves of that opportunity.
I'm sorry, I don't know what that means. Lowest barrier to entry, what are you saying?
My apologies. So when compared to, for example, other electronic possibilities like requiring the use of particular software packages or requiring, a particular level of technology, although it is true that there will be some people who do not have the technology to avail themselves even of this minimal system of electronic signatures, I think that number is much smaller than it would be if we were to implement other forms of electronic signatures.
Okay. Last question from me, I think. Right now, under the current legislation, the number of signatures required, say, for state Senate is 300. The number for the U.S. Senate is 10,000. The legislature has established effectively a ratio of 3% for state Senate signatures versus U.S. Senate signatures. Under your proposal, you would be changing that percentage, that ratio, would you not? You'd be essentially making it 6%. Because it would still be 300, but you'd be dropping it to 5,000.
That would be one effect of the proposal, and I would submit that what's important to take into account is not just the percentage reduction or a comparison or ratio as between two numbers, but also that there exists at some low number some absolute numerical threshold below which a candidate has not demonstrated sufficient public support to earn a place on the ballot.
But don't we recognize that the legislature took that into account in saying that you need 300 for state senate and 10,000 for the U.S. Senate? I mean, there is some proportionality there, and your proposal would be disrupting that proportionality.
There is some proportionality, but I'm not sure that the way that the proportionality between those two numbers reflects a legislative judgment that some number below 300 would demonstrate the appropriate amount of public support for a state Senate candidate to achieve ballot access.
Well, how do we, in the absence of the legislature acting, I assume you're not suggesting that we should treat the Senate as reflecting a legislative purpose in the absence of the House acting as well?
I think it's not perfect evidence and it's not ideal evidence, but it is some indicia of some legislative intent.
By one of the two houses of the legislature?
Yes.
I have no further questions. Does any other justice have a question?
I do have one, Chief.
Justice Lowy?
Yes. I want to pick up on the electronic signatures and question Justice Kafker was asking about. Why? Well, this is very limited use of electronic signatures. Why wouldn't it be for us to engage in the least intrusive solution that we can, to say that electronic signatures are available, and that whether or not it's the job of the State Ballot Law Commission to determine whether that signature is valid or not, and the State Ballot Law Commission can look at the electronic signature that we're saying is available and determine whether it's valid or not.
I think that engaging, with or implementing the least intrusive and least disruptive electronic signature solution weighs heavily in favor of what the Secretary has proposed. Although there would remain an opportunity for objectors to challenge the authenticity of signatures at the State Ballot Law Commission, the character and nature of what such a challenge would look like would necessarily be very different if there were a system like DocuSign. So even if that software maintains some indicia of authenticity as to the signature, it's not apparent whether that evidence would be available to a potential objector, and what that would look like for the State Ballot Law Commission. And I don't think any of us want to sort of be back in the same place of engaging in litigation over whether someone can adequately preserve their rights at the Commission.
All right. Thank you very much.
I have one follow-up to that. So when someone signs with a wet signature, you have to produce like your license or anything. You just sign it, right? You sign it, you give. So when you send an email with your name, in certain ways, that's more traceable than the wet signature, isn't it? I don't understand what security is provided by a wet signature that's different from an electronic of any kind, even something as simple as an email that says, I support, this candidate. We're dealing with a lax requirement to begin with, aren't we? And now we're dealing with the fact that we can't meet in person. So I'm just trying to figure out if we're being more intrusive by changing the numbers than we are by just allowing electronic confirmation that you support the candidate.
Well, I think one issue, Your Honor, is whether having received an email with some sort of electronic signature, what ability the recipient or a potential objector has to know that that email, in fact, came from the source from which it claims to come.
How does the person know that the person who signed at the grocery store the piece of paper is the person who signed it? Isn't it the same? We're going to have the rolls checked to see if they got the address right and the name right, and that they were an independent, if they're voting either in the Democratic or Republican primary, or a Republican if they're signing the Republican candidates. I just don't know what we're doing that's different.
So I I think, even the current system of wet signatures, as Your Honor observed, is not completely impervious to people.
It's a trust system.
But I do think that with a wet signature on a dated petition, there is some ability of an objector to say that doesn't look like that person's signature. I know they were out of the country on that date, and they could not possibly have signed that petition in person on that date. And those things are a lot harder to do with an electronic signature. And with any form of wet signature, the benefit is being able to compare it to an exemplar to determine whether or not it differs as a basis for assessing whether it's a authentic signature.
Thank you. That's all I have.
Any further questions? All right, thank you. And that concludes the hearing in this case. We will assemble the case among the justices beginning at 3:20. Thank you.